Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about statutory waiting periods again. Why is that? Well, apparently everyone feels really emboldened after the big ruling out of the 10th Circuit in the matter of Ortega v. Lujan Grisham, which struck down New Mexico's 7-day statutory waiting period. Today, we're going to talk about a new challenge to Florida's 3-day statutory waiting period. Did not know Florida had a waiting period. Got to admit, Florida, your gun laws are a little goofy. You hold yourself out as a real patriotic state, and then you look at your gun laws, and you're like, what's going on there? There's a challenge that has now been filed. I think it's a challenge that's got some real teeth, and we're going to spend some time with the complaint today. So today, let's spend a few minutes and let's talk about, so why does Florida make you wait? Okay, America, coming off the heels of a huge win last week in New Mexico, striking down their statutory waiting period, we're going to talk about a newly filed challenge to Florida's 3-day cooling off period, as they call it. The case that we're going to be talking about today is Dunn v. Glass. It is filed in the United States District Court for the Middle District of Florida. This is a challenge to both Florida Statute Section 790.0655 as well as Article 1, Section 8 of the state constitution, known affectionately as the cooling off waiting period. Now, before we get too deep into the legal stuff, let's just step back for a second and just talk about plain English and simple understanding of the English language. Because if we're going to make every single person in the state of Florida undergo a cooling off period before they can take possession of their firearm, does that not presume that every single person who is attempting to purchase a firearm in the state of Florida is heated over something? That for some reason they're in some kind of an emotional distressed state, and therefore they all need, across the board, 3 days to cool off. And that is one of the big problems with statutory waiting periods is that we treat every single would-be gun owner in a state as some potential nut job or someone who's clearly up to nefarious, sinister, or criminal intent, and therefore we must make them wait before we can actually allow them to exercise their right. Now, I want you to take that logic and I just want you to apply it right now to other types of constitutional rights. Let's just start in the First Amendment, for example. If the press wanted to run a story because a big story had just broken, but we made the press wait, 3 days, we need you guys to cool off for 3 days before you publish that story, would you find that to be unconstitutional? If you suddenly had a streak of spirituality come over you, or you were met with some kind of a situation in life where you really needed some spiritual guidance and you wanted to go to church right away and pray on it or talk to your pastor or do whatever, but the state had a 7-day cooling off period. You got to chill out for 7 days before you can go to church. Would we find that to be constitutional? Let's say that something the government has done has absolutely upset you and you want to take to the streets and peaceably protest. Can you do that? Well, what if you had to wait 5 days, excluding holidays and weekends, of course, before you could actually take up your First Amendment activity? Would that be constitutional? Hey, let's take it outside the First Amendment. You got a Sixth Amendment right to counsel. You are now accused of a crime. You have the right to an attorney after you wait the mandatory 10-day waiting period. Is that constitutional? And so that brings us to today's case, which obviously this law is going to have to be justified using the Bruen test, which means the question we're going to ask ourselves first is, does the plain text of the Second Amendment cover this activity? Well, this is about the ability to acquire a firearm, and therefore it absolutely positively is covered by the Second Amendment. Therefore, can the state of Florida justify the existence of this statute through historical analogs? And that, my friends, is where the argument is going to fall apart for the state of Florida. As the plaintiffs properly point out here, therefore, because the cooling off waiting period provisions prevent individuals from possessing bearable arms for a period of 3 days, conduct that the Constitution presumptively protects, the plain text of the Second Amendment is implicated. Plaintiffs have met their burden under Bruen, and the cooling off waiting period provisions are presumptively unconstitutional. Now, the state of Florida very well may say, hey, these are just commercial regulations. This is just part of how we regulate transactions relating to firearms. The plaintiffs put it this way: moreover, the cooling off waiting period provisions are not commercial regulations such that they are directed at ensuring the sellers of firearms comply with the law. Indeed, the very purpose of the law is to limit the ability of a purchaser to obtain a firearm. Yeah, see, we understand that FFLs cannot transfer firearms to individuals until the background check has been cleared, and sometimes that may take multiple days. That in alone will subscribe a waiting period that nobody has control over. But the fact that we're calling this a cooling off period doesn't mean that we're doing anything related to the transaction at all. What we are doing is we are presuming that the purchaser needs to be cooled off, and then we are giving them or requiring them or mandating them a time for them to engage in that cooling off. The fact that the cooling off waiting period provisions contain exceptions for holders of a concealed weapons permit, for the trade-in of another firearm, for the purchase of a rifle or shotgun by a law enforcement officer, or by those that have completed a hunter safety course demonstrates that there are some classes of purchasers for which Florida does not think a 3-day waiting period is necessary. If the cooling off waiting period provisions were a true commercial regulation, it would not maintain exceptions based on the category of purchaser. Well, that is exactly true. And again, the whole title of the statute, cooling off, is presuming that everyone who's trying to purchase a firearm is in some kind of an emotionally unregulated state and needs that period of time to, I don't know, get their feet back under them, to calm down a bit. And listen, if we go back through history, we don't have to go that far back to find the first true waiting periods. Yes, were there delays that were built into the firearm purchasing process? Absolutely. Delays necessary to conduct background checks. The existence of the first we're not going to let you do it for a period of time just because we, the state, know better, that didn't happen until the mid-20th century. So is there historical analogs to justify the existence of Florida's waiting period law? No, there is not. And it leads the plaintiffs to argue it is impossible for the state to meet this burden because there is no historical tradition of firearms being regulated in this manner, either at the time of our founding and the ratification of the Second Amendment or during the Reconstruction era and the ratification of the 14th Amendment. Okay, and then of course we've got to talk about, that's right, remedies, because remember, we don't have a lawsuit unless we're asking for remedies. What exactly is the plaintiff asking for here? Enter a declaratory judgment pursuant to 28 United States Code Section 2201 that the cooling off waiting period provisions violate the Second Amendment both on their face and as applied to law-abiding citizens purchasing a firearm for self-defense who pass a background check in less than 3 days. The plaintiffs also want enter permanent injunctive relief enjoining Commissioner Mark Glass, Attorney General James Uthmeyer, State Attorney Melissa Williamson Nelson, State Attorney Brian Stewart Kramer, State Attorney Susan Shorter Lopez, and all of their officers, agents, and employees from enforcing the cooling off waiting period provisions. Okay, like I say, the case was just filed in the United States District Court for the Central District of Florida. The case, once again, is Dunn v. Glass. We're going to link up the complaint down below so that you can geek out on it for yourself. You don't have to take our word for it. And yes, we will carefully watch this case because clearly challenges to statutory waiting periods is kind of one of the issues du jour that is kicking around right now. Now listen, in the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people.
Right.
We come from a significant significant gun background.
Right to bear. That's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.